Good morning, everyone. My name is Brittany Atkinson, and I'm here today with my partner, Jen Brennan. We're both attorneys at Chartwell Law. First, before we get started, I wanted to thank everybody for tuning in today. It would be ideal to do a face-to-face presentation, but we're lucky to be able to put on these webinars so that we can all stay connected. And with that said, I hope everyone is staying healthy and safe. We wanted to get together today to discuss some important case law that recently came down from the Appellate Division, which significantly affects medical provider claims in New Jersey. And I'm sure most of you heard about these two cases. It was actually two cases that came down, and Jen's going to get into them in some greater detail later on. But it has been a favorable opinion for the employer, and we wanted to take an opportunity to really discuss the details of these cases, as well as what it means moving forward and continuing to defend against medical provider claims in New Jersey. There should be a Q&A box at the bottom of your screen, so feel free to type in any questions that you can think of throughout the program, and we can address them all at the end. If you think of anything after the program today, we want you to feel free to reach out to us directly. You should have received our contact information, so email or call us. We're more than happy to address anything, any questions or concerns that you have after today. Before we get into the new case law, I wanted to briefly go over how we got here with medical provider claims. For years now, one of the hot topics has been medical provider claims in New Jersey, and really specifically the jurisdictional issues that come with it. And for those of you who may not be familiar with medical provider claims, basically, the doctor has the ability to seek reimbursement for alleged improper payments in connection with treatment for workers' comp cases. And they do this by filing medical provider claims with the New Jersey Workers' Compensation Court. What was never clear, and which has raised a lot of issue, were the jurisdictional limitations on these claims. So we started in the past few years seeing a ton of claims come in that were really in connection with out-of-state injuries. So for example, an employee is working in New York, he was hired in New York, the employer is based out of New York, and he gets injured in New York, but for one reason or another, he comes over and treats in New Jersey. So the doctors started bringing these claims for improper payments before the New Jersey Workers' Compensation Court. And why did they do this? Why did they start bringing these claims? Well, it's very simple, and most of you already know this, but in New Jersey, payment for medical providers or for medical treatment is statutorily paid pursuant to what is usual, customary, and reasonable. And this is what we refer to as UCR. But in the surrounding states, particularly New York and Pennsylvania, those providers are being reimbursed pursuant to a fee schedule, pursuant to a fixed rate. And more often than not, the fee schedule results in a much lower payment than what is allowable under UCR or reasonable rates. So you can see why the doctors started bringing their claims over here once they caught on to this. And there were specific firms that were, catching on to this. So we started really seeing an influx in these medical provider claims for out-of-state injuries. And really, just to put this into perspective, I mean, we have seen so many of these claims, but the difference between UCR and the fee schedules can be significant. One of the cases that I actually had recently, which I won't go into great detail about, but in UCR, it was they were paying for a surgery, and the provider was trying to prove that it was, it should be reimbursed based on UCR rates, and they were coming up with showing us that UCR was about $100,000, and in fact, I think it was $144,000. And then in the case was priced, the surgery was priced pursuant to Pennsylvania at about $18,000. So you can see the significant difference in why these doctors really want to push their claims towards New Jersey and not towards the other states. Like I said before, these claims were far and few at first, and we were using these jurisdictional arguments to, compromise them down and really resolve. But they have, in the past few years, really, we've really seen an influx. And I know that both Jen and I, because we handle North Jersey, we saw a huge influx up there, which is why we wanted to put this on today. And in fact, I think medical provider claims for out-of-state injuries account for about a third of your list, Jen, in Hackensack. Is that right?
Yeah, I think really based on the nature of where Hackensack is, so close to the border of New York, it's really grown a lot there. A lot of surgical centers where someone just crosses over for one day of treatment. It's definitely has a lot of cases up there.
Yeah, and I was seeing a lot of this in Patterson because I handled the Patterson list. So I guess the close proximity to New York was these people were coming, down for one day of treatment and, seeking reimbursement pursuant to New Jersey, which again could be significant. So, and really the workers' compensation court was up until about a month or so ago was really divided on whether or not jurisdiction was appropriate for these out-of-state injuries. Some of the judges, probably about half of them, found that in order for the New Jersey court to have jurisdiction over the medical provider claims, that it must have jurisdiction over the underlying claim. So if the claimant could not establish that jurisdiction was appropriate for his claim in New Jersey, the medical provider claim was getting thrown out. And actually, the judges weren't even throwing them out. They were just helping us resolve them for a lower amount, more so something that was closer to what they were owed in New York or Pennsylvania, as opposed to what they may be owed in New Jersey. But the other half of the judges disagreed with this. They were finding that jurisdiction was appropriate because the claim petition is not a prerequisite to filing a medical provider claim. And they were also reasoning that New Jersey has a special interest in ensuring that New Jersey medical providers are reimbursed pursuant to what is usual and customary, because they're a community, because they are in New Jersey, and this is where the services are being provided. So they were using that argument as well to find that jurisdiction was appropriate. So like I said, it was about half and half of these judges divided. So your defense was really, whether you were going to be successful, was really dependent on which judge you were before and or which venue you were in. But two cases were finally appealed, and the appellate court has given us some favorable precedent, and Jen's going to get into the details of these two cases that just came down.
Thank you, Brittany. And like Brittany just said, we have now had the first appellate level opinion on the issue of jurisdiction in these medical provider claims. It just came out in October, so it's really new. Two cases were actually appealed and consolidated for opinion by the appellate division, and they both involve similar facts. I'll tell you briefly about each one. The first one is Anesthesia Associates of Morristown versus Weinstein Supply Corp. In that case, the employee was injured in Pennsylvania, was a resident of Pennsylvania, and the employer was based in Pennsylvania. And the claim, actually, they had a claim filed with the Pennsylvania Bureau of Workers' Compensation. So all the connections were with Pennsylvania except for the employee's medical procedure that occurred in New Jersey. The provider was paid pursuant to the Pennsylvania fee schedule and then filed the medical provider application in New Jersey seeking the balance. And in this case, the difference was about $12,000. The judge of compensation in New Jersey found that the provider's claim was derivative of the injured employees, and that the underlying workers' compensation case needs to be compensable under New Jersey law in order for there to be jurisdiction over the medical provider application. So the judge of compensation in that case said there's insufficient contacts in New Jersey for the underlying claim to even be brought in New Jersey. And in that case, the medical provider was out of luck and the judge dismissed it. The second case was Surgicorp of Jersey City versus Waldman's. This was a case that involved similar facts to the first case, except for everything was in New York. So the employee lived in New York, the employee was hired in New York, worked out of New York, was injured in New York, and also the employee filed a New York claim against the employer. In fact, in that one, the New York doctor was the one who performed the surgery. The New York doctor actually filed a request for the surgery to be authorized with the New York Workers' Compensation Board. And in that request, the doctor listed the employer's address as being in New York. The Workers' Compensation Board in New York did find surgery was needed and related it to the workers' compensation case, said the employer was liable to pay for it, but to pay for it per New York law. So the surgery then occurred at a facility in New Jersey, and that was the basis for the medical provider application in New Jersey. The provider was, of course, paid per the New York fee schedule, and in that case, there was a very big difference in what was billed versus what was paid, because pursuant to fee schedule, the difference was over $230,000. So that's a lot. the judge of compensation in New Jersey looked at it and said, essentially all of the material connections are with New York, except for this one-day surgical procedure. And dismissed the medical provider application. The judge basically said that this is a single contact with New Jersey. It's a one-day treatment, and it's not enough to vest jurisdiction. The judge also talked about how the provider had to be aware it would be paid pursuant to the New York fee schedule when it applied for authorization directly from the New York Workers' Compensation Board. Another thing that's notable in this case is that the provider did try to argue that because the employer had locations in New Jersey, that there was a basis for jurisdiction. The employee that was injured did not work out of New Jersey, so the judge said no, there's not enough connection to New Jersey just because there's business by that employer in New Jersey, because the injured worker did not work there. They were hired out of New York, worked in New York, so no, the judge dismissed it. So those two medical providers appealed, and the appeal was consolidated for the decision. And basically they argued in their appeal that the New Jersey Workers' Compensation Act gives the Workers' Compensation Division in New Jersey exclusive jurisdiction over medical provider claims, even if there is no basis for workers' compensation. Even if there is no claim for workers' compensation by the injured worker in New Jersey. So they were trying to argue that the Workers' Compensation Division has exclusive jurisdiction over these medical provider claims, regardless of whether a workers' compensation claim is filed in New Jersey by the injured worker. The Appellate Division the medical providers tried to argue that there's a separate cause of action rooted in breach of contract over which New Jersey has jurisdiction through the Workers' Compensation Act as another way to try and argue jurisdiction. The Appellate Division looked at their case and discussed Section 15 of the Workers' Compensation Act. Now, this is the one that was amended in 2012 and gave exclusive jurisdiction to the New Jersey Division of Workers' Compensation over disputed medical charges arising from claims for compensation for work-related accidents or illnesses. Now, the Appellate Division looked at this and looked at the legislative intent of that amendment and said the purpose of the amendment in 2012 was to address the increase in billing disputes that was happening between insurers and medical providers. That the amendment was not meant to apply to all medical provider claims where the Division of Workers' Compensation wouldn't have jurisdiction over the underlying accident. So if there's no jurisdiction over the underlying accident under the Act, then the amendment was not meant to apply to those cases. Another thing the Appellate Division did discuss was the 6 factors that the court must consider when deciding jurisdiction, and they looked at Larson's workers' compensation law for that. It's the place where the injury occurred, place of the making of the contract, place where employment relation exists or is carried out, the place where the industry is localized, place where the employee resides, or the place whose statute the parties have expressly adopted by contract. And using those 6 factors, the Appellate Division noted they agreed with the 2 judges of workers' compensation that there was no clearly identifiable claim for a work-related injury by either of the employees, and so that there was no jurisdiction over the underlying claim, that there was no, that the judges were correct in tossing the cases. So the Appellate Division agreed with both compensation judges that the 2012 amendment did not apply to these medical provider claims where the division does not also have jurisdiction over the actual injury of the employee. Also, the Appellate Division did address briefly the argument that providers brought about breach of contract and said it was unsupported by evidence. There was no evidence of any agreement between either provider and the employer. And so they, really briefly discussed that there was no basis for that argument and upheld the 2 judges of compensation. So that's a summary of the recent appellate opinion, and Brittany will further discuss what it means for cases going forward.
Yeah, Jen, thank you for that. What I find most interesting is in both of these cases is that the treatment in New Jersey was really limited to a single one-day visit at a surgical center. So had the employee treated, maybe the doctor and the surgical center was in New Jersey, I wonder if that would have changed the appellate court's decision to determine whether or not jurisdiction was appropriate, because based on my conversations with a lot of the division judges, even the ones that agreed that jurisdiction under these circumstances is not appropriate, They were looking for more than just one contact with New Jersey. They felt that, one single day of treatment in New Jersey is just not sufficient to confer jurisdiction. But had there been more treatment or more contacts, they would be more apt to find that jurisdiction was appropriate. Do you agree that that would have changed their mind?
Yeah, I do think it might, because one day of treatment at a surgical center is one thing, but if the doctor's regularly seeing someone in the state and then the surgery occurs in the state, I think that some judges might be more inclined to find at least some connection, to hold it in, and encourage, they probably would encourage a settlement in that matter. But and based on my conversations as well with the judges, I think they're really looking now for cases that are very similar in facts to these two that were appealed, where there's just the one day of treatment, and it's pretty clear that I think they're going to be willing to dismiss those now.
Yeah, and another thing I was thinking about when I was reading through these cases is that in both of them, the employee lives outside of New Jersey. Now, we know, it's longstanding practice that residency in New Jersey alone is not enough to confer jurisdiction, but maybe that coupled with, one single visit or perhaps, a few visits would be enough to confer jurisdiction. So we'll be looking to see how that would play out as well. Another issue that always bothers me when I, argue for these medical provider claims against, for lack of jurisdiction, is in New Jersey, the carrier authorizes treatment. They control treatment. In Pennsylvania and New York, that it's not the same way. I know after a certain period in Pennsylvania, the employee is able to go out and treat on his own. So it was always, for me, an argument. It's unfair to the carrier in New Jersey to have to, be stuck with these bills that they basically had no idea or, no way to compromise or no way to really control. But they're supposed to pay pursuant to what is compensable medical treatment in New Jersey. So that's another argument that I've always used for these jurisdictional claims. Something else that's really important is, Jen, I think you were going to touch on this too, is are they appealing? Didn't you say they were?
Right. So both of the cases that were taken up on appeal, the providers have the same attorney. So they've confirmed that they're going to appeal. There's no right of appeal to the New Jersey Supreme Court, so they have to seek certification. Based on what we've heard from them, they're not confident that they will get certification, but they are going to try. Whether or not that might make some judges wait for now, which I also have discussed with another judge in another venue, which I think it's going to make them wait a little bit just to maybe dismiss more cases to see if the Supreme Court in New Jersey grants certification or not. So it could delay some dismissals happening at least immediately after this appellate case.
Yeah. And another thing to remember also is that these cases are unreported and therefore they're not binding on the workers' comp court.
That's right.
Yeah, we do have some questions. So one of the questions is the case is not binding. So I just actually touched on this. So how does this help us out? So yes, the case is not binding. So the judge of compensation does not have to rule that way. However, those judges, and I have talked to many judges about this case, they will be looking to that case as guidance. So a lot of them are going to be going off of that case, and it's only going to strengthen our arguments as well. So, perhaps we're not getting the dismissals that we want, but maybe we're settling them for, much lower than, we had anticipated at the outset of the case before these cases really came down. Another question we have, should we file for dismissals on the existing claims? Jen, do you want to take this? Because I feel like you touched on that a bit.
Sure. I think it would not hurt at all to file dismissals now. It gets them in the works, especially now with the courts being closed to in-person hearings. I think it might be delayed getting a dismissal, but I think it never hurts to get it in the pipeline, get it before the judge. And based on my conversation with at least one of the judges, I think that we might be able to move some of the dismissals sooner rather than later. So I think, yes, file it, get it going, get it in the works. And, if you can get it dismissed before certification is, say it's granted, good, you never know. So I say file it. Yeah.
Absolutely. I agree. Another question we have, would it make a difference if there was multiple days of treatment instead of one? I guess we touched on this a little bit, and I think both Jen and I agree. I think it will make a difference because the judges are really looking to establish as much contact as they can. So if you're talking about one single day of treatment, you don't have enough or sufficient contacts. If you have a ton of treatment, the doctor's there, the surgery's there, your follow-ups are there, I do think that could make a difference in whether or not the judge could find jurisdiction appropriate. Do you agree, Jen?
Yeah, I agree. I think it could make a difference. Every case is going to be very fact specific. The judges are really going to look at the facts of each individual case. And anything that could possibly be enough of a connection to New Jersey, multiple dates of treatment certainly could be. And I think that it's possible that some judges would say that's more than enough to keep it in New Jersey.
I agree. We have another question. In cases of surgery, I've seen a lot of New Jersey providers request an authorization letter specifying which hospital will perform the surgery. If a claim is in another jurisdiction, how should we word authorization letters in order to preserve our argument in case a medical provider application is filed? So the question hinges on whether you're authorizing treatment say, for example, for a Pennsylvania case, but that surgery is going to occur in New Jersey. I think it will come down to, again, first, whether or not that claim is going to be determined to have any connection to New Jersey, despite the surgery actually occurring in New Jersey. And specific wording, Jen, do you have anything for this?
Yeah, I've thought about this before too, because I have a lot of the crossover with New York cases. And a lot of times what happens there is that the treatment's authorized through the New York Workers' Compensation Board, but it'll be the doctor applying for authorization for the surgery gets approved. But there's nothing specifically that says where it has to be done. So then they go to these surgical centers in New Jersey and the carrier says, well, I authorized the surgery, but I didn't authorize it to be in New Jersey. I don't think there's specific language on those forms because they're forms, I think, that are done in New York. But if there's a way to maybe word it that you're authorized to perform the surgery at, and if there's a certain facility or at a facility in Pennsylvania or New York, to keep it more specific to the state rather than just allowing the doctor the ability to just go into New Jersey. Because frankly, I think that some of these doctors might have ownership interests in surgical centers at times. So it's in their interest to do the surgery in New Jersey if they think they can get more money. I just think that if you can, in the different state, word it specifically that the authorization is maybe only for this procedure in Pennsylvania or only in New York. Again, I'm not certain that New York allows that because it's a form and they just are saying the surgery is authorized. I don't think there can be a restriction on the facility, but maybe word it that way. Does that make sense, Brittany?
Yeah, I think if it was specific, I think it would go by operation of law as well. Like we would strengthen our argument to keep it out of New Jersey. But again, if they go and get that treatment in New Jersey and they can establish the contacts, then I do think that maybe they could have an argument. But again, be as specific as possible because it will only help us in court when we're arguing.
Right.
So it doesn't look like we have any other questions. Again, if you think of anything after this, please feel free to contact us directly. We will be posting updates on the status of the appeal to the New Jersey Supreme Court. So we'll keep everybody updated on that. I want to thank everyone again for tuning in. You should receive a follow-up email with our contact information. So again, email, telephone call, whatever you feel. And we're happy to discuss this further. So again, thanks for tuning in and we will hopefully see everyone soon. Take care.
Thank you.